Our special committee on litigation reform. I will have some special litigation, maybe. Also known as the Alex Riley Hour. So today we're going to hear two bills. Before I start, though, I'd just like to remind everybody that one of the hallmarks that I've noticed in this committee is we treat everybody with respect. We don't get into name calling. We don't have cantankerous debate, and I really appreciate that. I think that's kind of part and parcel of being a lawyer, and this committee is made up of all lawyers, I believe, and I think that's one of the reasons why we treat each other's we deal with each other's positions and arguments rather than the person. And I'd like to remind any of the guests that are here or witnesses to testify to please follow by those same rules. I also, like judges that I practice in front of, I assume you all know how to read, and all of our committee members certainly know how to read. Therefore, I like to keep these hearings short because we all know the issues. A lot of us have practiced in these areas, and we've certainly read the bills before we get here, and I expect that. So I limit. I call them star witnesses to 5 minutes and supporting witnesses to 2. I also ask that you try not to be redundant. If you need more time than that, I'm usually pretty easy on that. But just keep it in mind when you're testifying. So with that, excuse me, I will ask Representative Riley to take the hot seat. Oh, I'm sorry. It's been a while. It's the first committee I'll hear. Please call the roll.
Chairman DeGroot.
Here.
Vice Chair Black. Here. Representatives Ellebrocht, Anderson, Cristofanelli, Coleman, Hardwick, Riley, Rogers, and Trent.
Glad you could make it, Representative Ellebrocht. Glad you could make it.
I'm glad I can make it too.
All right. Representative Riley, why don't we start with, we'll just go numerical order if that's all right with you. House Bill 1715.
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. My name is Alex Riley. I'm the state representative from the 134th District, which covers parts of South and Central Springfield and Greene County. House Bill 1715 should look familiar to all of you, as I presented it to you last year and we voted it out of this committee around the same time last year. So as a reminder, this bill is a reform to our state's collateral source rule, and it really has two main components. So the first component is that if a plaintiff who has filed some type of personal injury case has received medical treatment and there has been some sort of reduction in the sticker price, the cost of that person's medical care. That person has, for example, insurance, Medicaid, Medicare, something along those lines, where the hospital, the medical facility has accepted some amount less than that sticker price, then the sticker price does not get to go into evidence at trial. What gets to go into evidence is that amount that the medical facility accepts to satisfy the cost of care. And the reason for that is simple. That sticker price number is frankly meaningless. It has no meaning whatsoever because no one's on the hook for that. So it's really a problematic thing to allow plaintiffs to come into court and say that they've sustained monetary damages in an amount that they have not, that they can use this frankly meaningless number to artificially inflate their damages at trial, and that's patently fundamentally unfair. So that's the first component of the bill, is that situation. And then the second has to do with situations where a plaintiff may have sustained an injury in the recent past and then receives or sustains another similar injury, and that person hires an expert or tries to come and testify at trial that he sustained this injury and the cost is going to be a certain amount. But when in reality, that person has received similar treatment in the recent past, and that cost was not anywhere near what the plaintiff claims, or what more likely the plaintiff's expert is going to claim is the future cost of that care. So that's what the second provision is it says that in that type of situation, then the defense would be able to present evidence of that prior treatment, that same or similar treatment, as evidence to help disprove what the plaintiff's expert is saying. And just to clarify on this provision, you have trial courts around the state doing different things on this issue. So some courts are saying that what I am proposing in this statute is already allowed, that that's the law, and you have others that are saying that that's a violation of the state's collateral source rule. So this just clarifies that that is indeed admissible evidence, and in my opinion, is not necessarily a drastic change in the current state of the law. So with that, I'll close and open myself up to any questions.
Thank you, Representative. I'll start. I've got just a couple quick questions. And I think I know the answer to this. Haven't been familiar with this bill in the past. What's the danger in letting someone say that, letting a plaintiff's attorney or a defense attorney for that matter, say that the medical damages in this case were $100,000 when they were actually settled for $25,000?
Yeah, well, I appreciate the question. The whole point of our tort system is to compensate that plaintiff for the injuries they actually sustained and try and make them whole as best money can do. It's not to put them in a place where they're now doing better financial-wise than they were before the lawsuit. And that's what happens when you allow plaintiffs to come into court and say that they've sustained damages in an amount that they really haven't. So that's what this bill seeks to address. It seeks to make sure that our tort system is doing what it's supposed to do, which is compensate our plaintiffs who've been wronged at no fault of their own, but it's not to put them in a more advantageous position.
What effect do you think that has on a juror who hears that somebody received $100,000 worth of medical treatment as a result of this injury rather than $25,000?
Well, I don't want to speculate on what an individual juror may do, but you're going to have some jurors who, for whatever reason, they're going to certainly be sympathetic to that 100,000 number.
Right, and maybe unjustifiably so.
Correct.
Maybe. Okay. And then finally, you mentioned the second part of your bill, which I think is new this year, right?
So we added this in committee last year.
Okay.
So this was in the language that we voted out of committee. We did add it as an amendment after my public testimony on it last year. But that was a piece in the bill that we voted out of committee last year.
And if you can, flesh this out briefly for me. Give me a real-life example. I mean, obviously, doesn't have to be names and all that, but an example of exactly the situation you're talking about. And if you can't, I see Mr. Freeze is over here, and I'm sure he's going to be able to help us out.
Yeah, so this has become increasingly prevalent over the past few years. I've experienced it myself in cases that we had going to trial. So I'll just give you more or less the example that we had. So we had a situation where a lady slipped and fell at a retailer, and she had to receive some medical treatment, and one of those things that she was set to receive was a knee replacement. And she had also received a knee replacement not that long ago. I can't remember the exact years, 2-3 years ago, something like that. It wasn't a great distance in time. And we knew what the cost of that treatment was. And she had hired an expert who was going to come in and testify that this knee replacement was going to cost her some extremely extravagant amount that really didn't seem to be based in reality. And we on the defense wanted to be able to show that she's received this exact same treatment just a couple years ago, and the cost was significantly lower. And in that situation, the court did not allow us to present that evidence. And we're seeing that very different results around the state. It really is depending on individual trial judges as to what some are still allowing it, increasing numbers are not. And this is to clarify that number can go in, that's something the jury can consider.
So kind of drawing the dots, a skeptic or a cynic might suggest that that higher number was placed into evidence because the plaintiff wanted more.
Right.
Any further questions for this witness? Okay, seeing none. No. We'll let you hit cleanup, Representative Ellerbach. We'll go with Representative Rogers. Go ahead.
It's hard to pick here. Well, thanks for presenting the bill. This slip and fall case, did that end up going to jury trial?
It did not. It resolved shortly before trial was set to begin, not in small part because of that ruling.
So in these cases you're talking about working on in the past, hey, have you tried any of them in front of a jury?
So as far as this specific issue in Section 6, that has not come up in a case where we've tried it. As far as the other provisions, yes, that comes. I've tried a number of cases. I do medical malpractice, premises liability, products liability. This is an issue in most of those cases.
And here's what, so I'm glad that you said that, because here's what I'm getting at. When the jury trial is over, I assume you talk to the jurors?
Yes.
I was a prosecutor for years, and now I do some civil work, and I've tried dozens of jury trials, and literally to a jury, to a juror, I've never thought anything other than these are really smart, hardworking, dedicated people who thought seriously before making their decision. And so, well, first of all, just let me ask: have you had that same experience, or have you had a different experience?
Largely agreed.
And so, if we got these great jurors on all these cases, they can sort through what's baloney and what's not. And to me, my biggest fear, especially when I was a prosecutor, I had a higher burden, but my biggest fear in a jury trial is overpromising something and then not be able to present evidence to back that up. So I'm frankly not convinced that changing the collateral source rule is going to hurt plaintiffs for that very reason. If you go in there and say you've got $1 jillion in medicals and it turns out you twisted your knee, you're not going to win. And so I'd love to hear your thoughts on that.
Yeah, so I would say, so most of the plaintiffs' firms that I have experience with agree with you. So most of them don't present that number because they know that there's going to be some skeptical jurors. The issue is there are some firms that we deal with on a regular basis that certainly don't do that. And there are...
do that, you mean present the actual number?
Yeah, that's right. Or at least threaten it. So most of those cases with those firms don't ultimately go to trial. But that does become a really big issue in the settlement negotiation phase, as you would probably know with being on the plaintiff side. So the reason it's still important...
How do you know I'm on the plaintiff side?
I'm sorry?
I was joking. I said, how do you know I'm on the plaintiff side?
Oh, well, I may have made an assumption there if you didn't say that previously. But so the reason, though, that is an issue is it still plays a part in the settlement negotiation phase because on the defense side, when you are visiting with your clients and they're having to consider all the various factors and risks of whether you want to settle a case, do you want to take it to trial, we have this bad law on the books that they have to think about. And while I think you and I have had similar jury experiences with regard to their overall reasonableness, you're still not guaranteed to get that. It's still a bit of a wild card. So it really plays a role in that settlement side of things where they have to consider this and perhaps put more money forward than they would otherwise want to because of this bad law in the books.
So in your own personal practice, have you tracked when you try? And I'm not talking settlement. I'm talking actual jury trials. Have you tracked the differences between when a plaintiff brings up a number and when a plaintiff doesn't?
So in the trials that I have personally tried that have gone to trial, we have been able to agree on a number that gets submitted to the jury on this medical damages issue.
Okay. I think you answered my questions. Thank you. Thank you, Mr. Chairman.
Further questions? Representative Ellerbach. Proceed.
Hello, Representative Riley.
Hello.
Thank you for like as my colleague said, thank you for bringing the bill forward. I don't have a whole bunch of questions. I just have a couple. The first one being, why can't or why shouldn't a jury, like my colleague here was saying, why shouldn't a jury be given both the numbers?
So the issue is this is not a number that's based in any sort of reality. It's a meaningless number. That sticker price number, it has, again, it just has no basis in reality. So it's not an actual piece of evidence that should go forward because it doesn't mean anything.
I mean, I'm sure that to the doctor and the hospital that present the bill, it means something. Otherwise, they'd be in some trouble for fraud, wouldn't they, if they were overbilling?
I'm not involved in hospital billing practices, so I can't answer that question.
Okay, so you're not involved in hospital billing practices, and you can't answer that question. So on what basis do you say that that number means nothing?
Because in every situation, I'm unaware of any sort of instance where that type of where that sticker price number actually gets paid. I've never seen that. So
Right.
whether you're
so why can't the jury get both? Right? Because the larger question here is the constitutional principle that juries are the ones to determine a plaintiff's damages is basically at the core of this, right? And what your bill is doing is suggesting that we should take away from the jury their purview of being able to set damages, because that's their job, by limiting the information they have access to. And you agreed with my colleague, Representative from Clay County a few moments ago that most jurors are hardworking, intelligent people, and every case you've tried, that's been your experience. So why can't we trust them with this information?
What I'm saying is we have all kinds of rules about evidence and what types of evidence goes before a jury. And there's a rule that it has to be relevant. And I don't think a sticker price number that has no basis in reality is a relevant number.
Sure. And for years we've had the determination that insurance and insurance policies and what an insurance company actually paid is not relevant to assess a plaintiff's damages. That's always been the rule in Missouri. And what we're doing here is suggesting that we turn that model upside down. After more than 210 years of jurisprudence, 200 years? And we had the Spanish model before that, so like 210 or so years of jurisprudence in the state of Missouri and the common law that preceded it, we've always had the principle that the jury gets to determine the person's damages. And now what we're suggesting here is that the insurance company's evidence is what determines a person's damages, or at least limits the information to such a degree that the jury's left with nothing else. Is that something that you would agree with? I mean,
No, I don't. I think that what we're saying is that the plaintiff's financial obligation is what the jury is looking at. So when you have numbers that are not in any way related to what that actual obligation is, that's not relevant evidence. So there's no reason that gets to be presented to a jury.
But you just said a moment ago that you weren't familiar with hospital billing, so how do you know it's not relevant?
Because when you have instances where you have Medicare, Medicaid insurance, personal, private pay, whatever the case may be, you have hospitals that reduce what they say is required to satisfy the cost of care. So I do know that. I don't know how the sausage gets made behind the scenes, but I do know that in those types of instances, hospitals, medical providers, medical facilities will accept less.
But the practical effect of this, though, is because the way this is written and the way the evidence is going to be submitted, if I submit a hospital statement on what was paid, the hospital statement is very likely going to show what the original bill was and then what the discount was as well, right? So the jury's going to have this stuff on the documents in front of them. It's just they're going to be told to disregard the number that was billed and only account for the one that's actually on the paper, right? That's the practical effect of this. How else do you get those documents into evidence? What do those look like when you submit them to a jury if they don't look like that?
That's potentially one way. I know there's plenty of times that we redact certain things from documents that part of the document is considered relevant, part of the document is considered not relevant. So it wouldn't surprise me to have an instance where you would just redact those types of documents.
And in the process of discovery, like plaintiffs' attorneys and defense counsel, but mostly plaintiffs' attorneys, which I would think would concern the insurance industry, are going to be privy to some of these contracts between a health insurance provider and a hospital or a healthcare provider. So now we're talking about discovering the terms of contracts between who pays the bills and what discounts people are getting, how much they're actually getting paid on this stuff. Is that something we really want to make available to the public at large what the terms and conditions of these contracts for payment of services between insurers and hospitals really is?
I don't think anything in here changes the discovery rules. I think
That's right. That's what I'm saying. And so all this is going to be discoverable, and people are going to be able to see what those contracts between a healthcare provider and an insurer are. They're going to be able to get to the private terms of these contracts through discovery.
I mean, potentially, but I don't see that that's any different than, I don't think anything in here changes what's currently discoverable.
What's probably going to happen is that one health insurance company is going to have access to the percentages of which another health insurance company pays their provider, and they're going to be able to become a lot more competitive if they otherwise don't know. And I'm sure some of this stuff you can find out through the Department of Insurance or, you know, things like this that they keep record of somewhere else or whatever. But now people are going to be starting to see this. It's going to become a lot more public what health insurance companies are paying out for services. Is this something that, like, the health insurance industry is okay with?
Well, I think there's going to be a number of folks that represent that field probably testifying here in a minute, and maybe you can ask them about that.
I might if they carry health insurance, but if they're carrying policies for other types of insurance, I don't know that. I mean, they're probably here advocating for this because it's a lower number that they have to pay out on. But thank you for your testimony today. Appreciate it.
Further questions? I'll just follow up. When you get a credit card bill, what do you do when you get in your monthly mailbox?
Well, I pay my credit card bill.
Right, and you don't question it?
Right.
Right. And isn't that what most people do with their medical bills? When they get
I would think that's probably true.
Yeah. I don't really question the cost of Kleenex or anything. It's just it is what it is. And isn't that the point of your bill, that when these jurors, and you agreed with Representative Rogers earlier, saying that they were all good, hardworking, honest people for the most part. I agree with that too, by the way. In my experience, very, very few of them were experts in medical billing practices.
Sure.
Your experience as well?
Right.
Yeah. So when isn't it logical to conclude that when a jury is presented with a medical bill from a hospital, that they treat that pretty much like you and I treat a credit card bill?
I would think that's probably true.
And you heard the representative, and we hear that a lot, especially from the people across the street. We're invading the province of a jury, right? It's always been my thought, and I want to know if you agree with this, that we're kind of invading the province of a jury by suggesting a number that isn't based in reality, right? I mean, if we're suggesting that somebody received $100,000 in medical care, aren't we really prompting that person to award a higher amount in some cases?
I think that's true. And just to go a little, just to address that point further, I think you can make an argument that all of our rules of evidence invade the province of the jury. I mean, our rules of evidence keep irrelevant material out of trial. And all of that certainly has some impact on what the jury is able to consider. But I think we need to have a system that streamlines some of that to make sure that they're only looking at relevant evidence that has an impact on the case. And that's why I don't think this made-up number that just has no basis in reality in the vast majority of instances is relevant evidence.
And let's talk about your made-up number here for just a second. It's been a long time since I worked for Brown and James and tried fender bender cases, which is what I know. It was my experience back then. It's been a long time ago, I hate to admit, but it was kind of like, let's make a deal with the medical care provider. Is it still that way? Whereas they give you a bill for the medical treatment received as a result of an injury, we'll say, and both the plaintiff's attorney and the defense attorney looked at that number and said, okay, well, we'll cut the bill in half or whatever, and that in a lot of cases, and I think it puts the hospital in a kind of a trick box too, because under that system, if they don't present a high bill, they present what the treatment really should cost, they're stuck playing let's make a deal with a lower number, right?
Right.
Is that still what goes on?
To my knowledge, yes.
All right. That's all I have. Any further questions? Representative Riley, thank you.
Thank you.
Any witnesses in support? Mr. Freeze, I don't know when the last time you testified was, but please remember to fill out a witness card, state your name and your employer.
Thank you. Good afternoon. My name is Dana Freeze. I'm President and Chief Executive Officer for Healthcare Services Group in Jefferson City. We insure 63 not-for-profit hospitals in Missouri and approximately 2,000 physicians and thousands of nurses and other allied healthcare providers. I'm testifying today on behalf of the Missouri Organization of Defense Lawyers and the Missouri Hospital Association. House Bill 1715 clarifies the original intent of Senate Bill 31, which was passed in 2017, in terms of what should be admissible in evidence in relation to the definition of the actual cost of medical care or treatment which is recoverable by the plaintiffs. Currently, and as a result of the decision in Brancati v. Bi-State Development Agency, Missouri Court of Appeals, Eastern District, December 2018, trial courts are permitting the amount billed to be admitted into evidence. The end result of Brancati is that the jury is permitted to consider the following for purposes of determining what is the, quote, reasonable value of the medical treatment provided, the amount which was actually paid after adjustments for negotiated discounts, price reductions, write-offs, the amount initially billed by a healthcare provider before any adjustments, and the amount awarded by a jury often ends up being some arbitrary point in between those numbers because jurors are sometimes confused when presented with different numbers for medical expenses. House Bill 1715 corrects the alleged ambiguity that the court in Brancati found in Section 490.715 as amended by Senate Bill 31, and accomplishes the intent of the 2017 bill by expressly stating, which should have been inferred, that no party shall introduce evidence of the amount billed for medical care or treatment if the amount billed has been discounted under any contract, price reduction, or write-off by any person or entity, or satisfied by payment of an amount less than the amount billed. In other words, the actual cost of medical care is the amount which ultimately has to be paid for the medical care. What could be more equitable? Ensuring medical expense awards serve their purpose as a compensatory damages award. That was the public policy that this body expressed in 2017 in passing Senate Bill 31. A plaintiff is entitled to be made whole. However, a plaintiff is not entitled to be made more than whole or recover an amount in excess of the damages actually sustained or be put in a better condition than he or she would have been had the underlying wrong not been committed. If we are truly seeking to make a plaintiff whole, the correct measure of medical expenses is the amount paid or owed after adjustment and write-offs, including charity. The Missouri Hospital Association reported that for year 2019, the amount of charity medical care in this state and bad debt was $1.7 billion. Allowing consideration of amounts which will never be paid by anyone results in a windfall to the plaintiff and the plaintiff attorney, who typically receives a 33% to 40% contingency fee. That windfall isn't free. We all pay for it and higher insurance premiums, and it puts additional financial pressure on the businesses who pay those liability insurance premiums and address our economy and impacts our economy. Bottom line, House Bill 1715 is important because it ensures that the medical expense awards are serving their purpose as a compensatory damage award. It makes a plaintiff whole, but does not award them an amount in excess of the damages actually sustained. This bill corrects the ambiguity with Brancati and reinstates the public policy of this body that was adopted in 2017. Thank you for your time.
Thank you, Mr. Freeze. I remember back in 2017 when my first year in that legislation was passed. One of the arguments against passage of that bill was that it unfairly rewards those people who aren't insured. You're familiar with that argument?
Yes, I am.
Yeah. How would you address that?
Well, I mean, if there is not insurance to compensate a plaintiff, then the jury can award a judgment, and then it becomes a matter of whether that judgment is collectible. And, you know, if a party doesn't have insurance and you're awarding them more than what their damages are, what are you accomplishing?
I'm sorry. I was talking about the plaintiff who is uninsured.
Right.
Right? Because if a plaintiff's insured, then they submit the way I understand it, they submit their medical bills to their own insurance company.
Right.
And the insurance company then negotiates with the hospital, correct?
Right.
All right. So if the amount billed is $10,000 and everybody knows that the standard and reasonable cost for that care is only $2,500, then that insurance company will negotiate with your organization and pay the $2,500, right?
Right.
If that individual, that plaintiff is uninsured, and you send him a bill for $10,000, well, isn't that a windfall for him?
It is, because they're never going to
finish. And it actually a windfall for that guy, and we're rewarding him for not taking the responsible step of getting health insurance.
Correct, because for that plaintiff that's uninsured and receives a $10,000 bill, they're never going to pay that $10,000 bill. Every hospital in this state provides charity care, writes off bills, or if it's private pay, a very substantial discount in that bill. And if they assert a lien, a hospital lien, by statute, they are limited in what they can collect. So you're correct. In your example, if a jury awarded that uninsured plaintiff $10,000 for that medical procedure, they're never going to have to pay $10,000 to satisfy that bill, and that would represent a windfall for that uninsured plaintiff.
And in theory, a jury who bases their pain and suffering award on that $10,000 figure would also receive a higher award at trial, correct?
Right. If they're using that as a barometer or a formula to arrive at a pain and suffering determination, you are correct.
So is that just a loophole that we have to live with? It may be. Maybe that's the answer.
Well, I mean, you know, it may be a loophole. In my world of medical malpractice, we have non-economic damage caps, so that helps me. But it really boils down to this bill still permits a plaintiff to be made whole. It simply prevents a plaintiff from receiving a windfall.
Well, and the argument to that is it makes the uninsured plaintiff made more whole, right?
Well, beyond being made whole, but receiving a windfall. If they receive $10,000 for a medical bill and they have to pay $3,000 to satisfy the hospital lien, they've received a $7,000 windfall.
And perhaps even more for pain and suffering, correct?
Correct.
Yeah. So, and it may be just a loophole, but we are rewarding that person who doesn't take the responsible step of getting health insurance, correct?
Correct.
Okay, that's what I did. Any further questions? Representative Albrecht. Proceed.
Good afternoon.
Good afternoon.
I have just a question about the very last section here, because I know you're in the industry and you have a lot of knowledge, probably more knowledge than I do, and I'll admit that. But I have a question about this paragraph 6 here, directly to the bill. It's lines 34 and 35, beginning on line 33, but going into 34 and 35, where the plaintiff's case, the discounts pursuant to any contract, price reduction, or write-off shall be admissible evidence relevant to the potential cost of future treatment of the same type or kind. So the jury's going to be given all the information about the discounts. They're going to be given the information about the write-offs. They're going to be given the information about the charitable contributions. So how is it that the jury's not going to see the total billed amount in the first place? And if they do, why are we telling a jury to speculate on what the future contracts and the future discounts and the future deductions for treatment in the future are going to be? How is a jury supposed to predict the future with regard to those discounts?
Well, what I would envision would happen would be the plaintiff attorney, as they do currently, will submit a life care plan that would estimate that over the life of this plaintiff, they're going to need the following medical procedures, and based on current build rates plus a load for inflation, the future medical costs are going to be X dollars based on current billed amounts adjusted for inflation.
Okay.
What I would imagine the defense lawyer would do would be to receive approval from the judge to admit into evidence the amount paid for a similar procedure that the plaintiff has received to date that is of the same type as the medical procedures that the plaintiff lawyer claims the plaintiff will need in the future, and the jury would then be permitted to consider the amount that's been paid in the past for a similar procedure, but that would not be the only evidence the jury would be able to consider. They could also consider the plaintiff's life care plan as well, and then arrive at a determination of what is the appropriate amount of compensation that the plaintiff should receive for medical treatment that is anticipated for the future.
That was terribly confusing. But that's probably my inability to grasp most of what
So
you
in other
said.
words, I don't think the judge is going to let the defense lawyer show amount of write-offs and adjustments, just the amount billed. I mean, the amount
let me start
paid.
over again. I'm going to say back to you what I understood, and you tell me if I'm right or wrong. Is that okay?
Okay, sure.
Okay. So the plaintiff's lawyer is going to submit a life plan.
Life care plan.
Right. The life care plan is going to include the estimated costs of what we think this treatment's going to be.
Correct.
Correct. And then defense is going to be able to submit evidence of discounts, charitable donations, write-offs, deductions, things like this, in order to say it's not really worth X amount, it's worth Y amount. Is that right?
Well, I think what the defense lawyer would say is, in response to the life care plan, ladies and gentlemen of the jury, Mr. Jones had the exact same type of medical procedure 2 years ago, and the amount paid for that medical procedure was $20,000.
Well, wait, okay. What you're suggesting is that we admit irrelevant evidence of medical treatment of an unrelated accident. So
No,
how much?
no.
Okay, help me understand that.
Well, okay, let's just assume the example of plaintiff is injured and had a hip replacement,
Okay.
a year after the accident. And the billed amount for that hip replacement was $50,000. The amount paid by insurance was $25,000, okay?
Okay.
So the plaintiff lawyer says that 10 years into the future, the plaintiff is going to need another hip replacement surgery, and we project that the cost of that procedure is going to be $75,000 based on billed amounts adjusted for inflation. The plaintiff lawyer can make that argument, as I understand the bill, but the defense lawyer could also say, but ladies and gentlemen of the jury, a year ago, a year prior to this trial, this plaintiff had the same procedure that he is claiming he's going to need in the future, and the cost of that procedure a year in the past was $25,000. So what they're claiming for $75,000 for that future procedure is grossly overstated in terms of what the real cost of that procedure is.
So the plaintiff's lawyer is still going to get to present the total amount billed.
Yes, in terms of future medical, not past medical, but future medical.
Okay. So past medical, they don't get to present the amount billed because
That's
that's
right.
not relevant. But in future, in order for us to establish what the discount is going to be, in order for us to establish how much less money we're going to be paying out our constituents, we do get the full bill in. so
Right,
that defense
because-
can argue against it.
Right, because as I read subsection 6, the amount paid shall be admissible. It doesn't say it's the only admissible evidence.
So why can't we just allow the billed amount in at the trial phase for the original damages as well and let the jury sort it out? My original question to the representative that brought the bill. Let him have both numbers.
It's because we have had several jury verdicts, my company, where the jury awarded the amount billed, disregarded the amount paid for whatever reason, and that resulted in the plaintiff receiving a windfall and the defendant having to pay more than it really took to make the plaintiff whole. That's why, as a matter of public policy, this statute is important. That's why it was adopted in 2017, and we're trying to fix the ambiguity the court found in the Brancati decision. I'm not trying to change the policy here.
I mean, from what you just said, it sounds like, and I'm not trying to be rude, but it sounds like you're trying to change the public policy because you were mad that you lost a couple of jury trials. Like, that's what it sounded like, what you just said. That's what I heard when you said that.
No, I mean, when a plaintiff receives that kind of a windfall, that increases the liability insurance premiums, and we all pay for that expense because that is passed along as a cost of doing business. None of us should want a party to receive a windfall through the jury trial process. And that's what is happening when the juries award the billed amount, which the plaintiff is never going to have to pay. That is a classic windfall.
I mean, you keep using that phrase windfall, but we're dealing with people that were seriously injured in a lot of cases, in some cases dead, right? Like, I don't regard that as like much of a windfall.
Well, but
To have a serious bodily injury that probably alters the course of your life and in a lot of cases shortens it or ends it altogether, like that didn't seem like a windfall to me just because they got a couple extra $1,000. Like I would imagine they would probably rather have not been hurt or killed in the first place.
Of course. And the plaintiff is entitled to be made whole, but the amount that the plaintiff receives for medical expenses is just one component of their damage claim. The jury is free to award them a substantial amount for pain and suffering, disfigurement, lost wages, lost income, loss of consortium, etc. We're talking about one discrete component of a damage claim.
That's it. I'm good. Thank you. Thanks for the inquiry.
Thank you.
Any further questions for this witness? Seeing none, thank you, sir.
Thank
Make
you.
sure and leave your witness sheet.
Already submitted online. Thank you.
Thank you. Star witness in opposition, please step forward. Welcome to the committee. Yes. I don't think I've seen you around the Capitol before. I don't think you've ever testified in front of our committee.
The first time I'm coming here.
Oh, well, welcome. I'm really glad you're here. Where's Amy Gunn when you don't need her, huh? I'm kidding. What's your name?
Amy Gunn. Thanks. My name's Chelsea Oxen Dickerson. I'm an attorney and I represent injured people in Missouri courts.
Thank you.
First, I want to address this subsection 6. There was some discussion about the fact that it only affects people who had a very recent surgery and then are going to have a surgery in the future. I do not see time limitations on that. This gives defendants an unfair advantage by allowing them to introduce speculative evidence to unfairly and quite severely discount future damages to people who need future medical care. This bill is wrong and it will harm the most seriously injured Missourians. This bill is an attack on life care plans, which detail what treatment and cost these people need. And it's people who need treatment 10, 20, 30 years down the line. This is not about people who sustained bills in the past and fully recovered. This affects our most seriously injured Missourians and our most seriously injured citizens. These are people like those in our office who have permanent brain injuries and are never going to get better. It's like people in our office who have permanent spine injuries and need expensive surgeries moving forward and procedures. They need that care. This bill allows defendants to argue and obtain the benefit of entirely speculative information. I know and I heard the sponsor talking about a surgery that was going to happen very soon after a case, and he had one very recent before that. But the effect of this bill and the way that it's written is it doesn't just account and address those situations. It applies to everything. So if someone had a surgery or a procedure or a service of any kind 2-3 years before trial, and then they have a life care plan that forecasts out cost 10, 20, 30 years down the line, it's the same result. There's dangerous assumptions being made that that person will have the same health insurance, whether it's Medicaid, Medicare, private insurance, whatever the case may be. As we all know, people lose their jobs, they lose health insurance. That changes all the time. It also makes the dangerous assumptions that the same contractual write-offs or adjustments in a proportional amount to what they were before is going to stay the same after. That far out, again, the people who deserve the protection here are the most seriously injured, and those are the ones that need treatment 10, 20, 30 years down the line, and those situations are going to be much different. It also doesn't account for the cost of medical care going up. Just because somebody had a surgery that cost X 2 years ago doesn't mean it's going to cost the same, and I know they were talking about the plaintiff bringing evidence of a higher cost, but the defendants are not talking about that. They're talking about just taking the same proportional discount of what it was before, and that's entirely speculative. It's not always going to be the case that that's true. On subsection 5.3, this completely prohibits an injured person from telling a jury about what the full value and the full amount of their bills were. I know everybody's been talking about this paid medical as, oh, once you get an adjustment, it's just a be-all, end-all, and you're never going to have to pay that bill again. I want to present a very scary situation to you that I've been seeing more often for my clients. I'll give you an example with a client of ours who had a dog bite injury. She sustained $50,000 in medical bills. It got adjusted through her private health insurance and was $25,000. You think, great, it's discounted, wonderful. However, the biggest portion of that bill was a very large hospital in the Kansas City area. Once they found out that she got a recovery and she obtained money, they 100% revoked those adjustments and balance billed her, is what we call, for the full amount of the bill. So I've seen that happen with this case. I've seen it happen with another minor client who was injured by a drunk driver, where a hospital and other medical providers revoked discounts. So I don't want everyone to sit here and think that that paid medical amount is definitively 100% always going to be the case. These adjustments are moving targets. They really are. We can call a hospital one day and get a bill or said that it's zero, and they got adjustments and had health insurance paid, but then after they get a recovery, oh, sorry, we're not going to take those adjustments anymore. So it's a scary situation. I think it's more than fair, as stated and discussed previously, that the jury gets to hear both sides. It's fair, and it's the province of the jury to let one side argue their points, let another side argue their points. The plaintiff can introduce the higher amount, the other side can introduce the lower amount, and let the jury sort it out. That's the province of the jury. What's not fair and what invades the province of the jury is when you completely tie a party's hands behind their back and don't let them present otherwise relevant evidence to a jury. It is relevant for the reasons I talked about, and it's also relevant if a doctor gets up and says, yes, that's the fair value of my treatment. So for those reasons, please vote against this bill.
Well, thank you, and again, let me say welcome to the committee. I hope to see you again. You're gonna have to help me with the pronunciation of your last name.
It's Chelsea Oxton Dickerson.
Oxton Dickerson.
Oxton Dickerson.
Thank you.
Yep.
I appreciate that. I'll go ahead and start. Isn't it by its nature? I mean, trying to predict a life healthcare plan is speculative in nature, right? I mean, you don't know, as you sit in your chair today, what a knee replacement is going to cost 10, 15, 20 years from now, right?
So that's why a plaintiff brings in a physician expert and a life care planner expert, and instead of the plaintiff's attorney talking about it, it's the experts who the judge allows to come in and talk to the jury with their experience and training of what those things would cost. I think what's more speculative, though, is for the other side to then come in and say, oh, well, this person, we're assuming they're going to have the same health insurance. We're assuming that nothing in their circumstances is going to change down the line. We can more fairly forecast out what a surgery will cost 10 years down the line, for example.
In your cases, do you also take into account for damages future lost earnings?
Yes.
And isn't it necessary to take a snapshot of that person as to what their earning potential is right there at that moment? And aren't we making assumptions about the future that guy won't become an alcoholic or won't get unemployed or won't decide he just doesn't want to work? And yet we're stuck with that snapshot, aren't we?
Well, yes, it's a snapshot in time of where they're at, but I think the whole point of forecasting out those lost wages is to it's more aimed towards their disabilities and what they can't do, and what they can do and what they could earn in the future based on an economist and their physician testifying to those things as well.
I promise this isn't a gotcha question. I'm really interested. How long you been an attorney?
So I've been an attorney for 12 years.
Okay, perfect. That's a great deal of experience, and I'm not disqualifying that a bit. In your 12 years worth of experience, have you ever had an expert be wrong?
Be wrong. I've had juries say that they don't agree with an expert, but in my opinion, I'm always going to present an expert that I think is being truthful with the jury.
Well,
so,
I agree,
no.
but being truthful, you can still be wrong and still be an expert, right? I mean, in fact, I challenge you to find an expert that told you that a knee replacement 12 years ago, and have him predict or her exactly what the cost is today. It's almost impossible, right?
No, I think someone can fairly do that. I think what's unfair, though, is for someone to assume that they're going to have the same kind of health insurance and contractual adjustments. I think it's harder to forecast out what a contractual adjustment is going to be in the future than it is to say what the total cost for inflation would be.
Let's talk about those contractual adjustments, too. And that alarmed me when you were testifying earlier about the dog bite case.
Yes.
And how the Kansas City Hospital, I mean, you should talk to Mr. Freeze over here, but went back after the settlement, or I assume the case was settled?
It was settled out of court, yes.
Isn't that incumbent upon the plaintiff's attorney? And I'm just really interested about the situation. I'm not pointing fingers at you, but isn't it incumbent upon you to make sure that doesn't happen, that your client's protected? Don't you negotiate? That's what we always did. I'm from St. Louis. Maybe we practice law differently in St. Louis than you do over there. But isn't it incumbent upon you to protect your client, to make sure that doesn't happen when you negotiate with a provider like the Kansas City Hospital, saying, okay, you're going to take $25,000 even though your bill is worth $50,000, and we're going to hold you to that, right? Even if my client gets money later on, you're not going to try and garnish his wages.
Sure. So we're currently in our office trying to figure this out. Definitely. I mean, it's not something that we wanted to deal with, and it's by no fault of our own. The hospital just came back once they caught wind of the settlement and decided to do that.
I mean, they would do that in every single case, right?
Well, we're obviously trying to help our client in that situation. I guess what I'm trying to illustrate to everyone is that the adjustments are a moving target. And I think you raised an example of, if you get a bill in the mail, that's what you pay, and that's definitive. But we've all had an experience, too, where you get a medical bill in the mail, and they're wrong. Maybe they didn't bill your health insurance appropriately. Maybe they sent it too soon. There's all kinds of scenarios where that happens, and I'm sorry, but we see it all the time with clients. So I disagree with that.
I got to start looking at my medical bills a little closer, I think.
Haven't we all been there? I mean.
All right, I'm going to let you. Thank you so much for being here. Any further questions? Representative Albrecht. Proceed.
Ms. Oxton Dickerson, thank you for being here today. Thank you for your testimony.
Thank you.
I want to spend a little bit more time on these. What would you call them, contractual adjustments? Is that when the hospital comes back and like rebills?
Yes. The theory is, you got paid as the injured plaintiff, so why should we have to discount our bill?
Right. Now, because I've been in Kansas City, I've been in practice in Kansas City for like 11 years, and I've heard of this happening. Actually, you hear about it kind of fairly frequently. In your dealings with the bills and the medical bills and stuff like this, do hospitals or healthcare providers even engage with you if they know that there's like a settlement or a lawsuit or a potential for a trial on the damages? Are they going to even engage with you prior to, or are they just going to stand quiet and wait to see what happens?
It's really hard. It's becoming more and more difficult to try to call these hospitals, especially if they're very large hospitals. I can think of a few on my list that are harder than others. But yeah, you're trying to get a hold of someone who's typically not very well paid in their billing office. They don't want to answer the phone. You leave messages. I can't talk to you. You're the person's attorney. I need to talk to the person. I need a HIPAA. I need this. I need that. There's all kinds of excuses. So yes. The short answer is it's very difficult, and a lot of them know that. They want to get paid more, right? So their strategy is, I'm going to stonewall this person or make it difficult for you, and it's hard for us in that position because then our poor client, the injured person, is in this terrible situation when the defendant and the wrongdoing person should have just paid for it to begin with, or at least have that information submitted to the jury.
Right. So it's more to the chair's question about it being your responsibility or the plaintiff's attorney's responsibility to protect the client. My point there was that most of the time, at least in my experience and having heard of it from other practitioners, is you can't get anybody on the phone to deal with to get locked in on a price for the medical bills prior to the settlement in the first place. And then even if you can, they don't have the authority to bind the hospital to any kind of agreement in the first place anyway. So your client's going to get that bill on the adjustment, right?
Exactly.
And that
Yes.
happens fairly commonly, especially when a client gets a larger settlement, like in the like north of six figures kind of settlements.
Exactly.
Then the hospital's going to come back and rebill them, right?
Right, exactly.
And hospitals don't care about what types of damages, like special damages or consequential damages, or hospital don't care. They just see the big number at the end, right?
No, yeah,
And they're going to
that's
come
right.
back at our client and try to recapture the stuff that they've discounted or written off to charity, or all those things that they've knocked the price off on, with the exception of the things that they might have had a contract with the insurance provider, the health insurance provider for, right?
Exactly. Yes, it's a very scary situation for
So
us to
that-
deal with. Yeah.
So that many times when the actual amount paid at the time of trial doesn't tell the whole story at all,
Exactly.
right?
Yes.
Which is why it's important for the jury to get both numbers. Isn't that fair?
Exactly.
I would think that that's fair, that the jury could get both numbers, what was billed and what was paid. I don't see why that's an unreasonable suggestion.
Exactly. And I would also just bring up the scenario, and I think I mentioned this quickly, but a doctor testifies or has the affidavit where they definitively say this is the value of the medical treatment. It's definitely relevant. There was discussion of it being a price sticker that is meaningless, but if a doctor is talking about that, it is very real. And in these scenarios, it's very real too.
Right. And one last question, just sort of like kind of wrap this up. There was a practice for a while, at least back home in Kansas City, of people just not submitting medical bills at all. Are you familiar with that one?
Yes,
Just
absolutely.
not plead them at all.
Yes.
And this bill allows the defense counsel to bring in the medical bills to make that relevant when the plaintiff isn't pleading medical bills at all. They're just pleading the harms and losses suffered. I'm not going to bring up hospital bills because I don't want you guys bringing that stuff up.
Right.
And this allows them to then, my reading of it, what do you read it the same way? And is that problematic for our constituents who happen to be plaintiffs?
To be honest with you, I think in most situations when we try to not bring in the medical bills at all or don't seek that and it's only non-economics, there's usually a motion in limine on that point. But you're right, it depends on what the judge is going to do with that. So if the judge still says that they can bring that up, then yeah, it's definitely problematic that there's just that one number going to the jury and both sides are not being represented fairly. Yeah.
Thank you for your testimony today. Appreciate your time.
Okay, further questions? Seeing none. Mrs. Axton
Dickerson.
Dickerson, thank you so much for being
So
here.
much.
Come back anytime. You're more than welcome. All right, we're going to move into the abbreviated portion of our testimony. Anybody in favor, please step forward.
Mr. Chairman, members of the committee, Jorgen Schlemeier, very abbreviated. On behalf of the American Tort Reform Association, also the Missouri Railroad Association, we'd like to go in favor of this bill.
Thank you, Mr. Schlemeier. Any questions for this witness? Seeing none. Next witness in support, please step forward. Mr. Gibbons.
Thanks, Mr. Chairman. Michael Gibbons, representing both Bayer and Enterprise, just to go on record in support of the legislation.
Thank you, sir. Any questions for this witness? Seeing none. Next witness in support. Mr. McCarty.
Chairman, members of the committee, Ray McCarty, President of Associated Industries in Missouri, want to go on record in support of this bill and say this is fine language. I wish we would have done it the first time, Mr. Chairman.
Me too. Thank you, Mr. McCarty. Any questions for this witness? Seeing none. Next witness, Mr. Jackson.
Thank you, Mr. Chairman. David Jackson on behalf of the Missouri Society of Anesthesiologists, the OBGYNs, Ambulatory Surgery Center Association, and Reyes Radiology. Want to go on record in support.
Any questions for this witness? Seeing none. Next witness in support, please step forward. Hello.
Good afternoon. Good afternoon, Mr. Chairman, committee members. My name is Carol Mitchell. I'm with the Missouri Chamber of Commerce and Industry. The Chamber has a long-standing policy of supporting clarification of collateral source rule. We think that this ensures that more accurate decisions are being made regarding the rewarding of damages. And this brings more fairness to our courts. So we support this legislation.
Thank you. I can vouch for that. And say hello to Mr. Meehan for me.
I will.
Yes. Any questions for this witness? Seeing none, thank you. Next witness in support.
Mr. Chairman, Brad Jones with the NFIB. We once again, we supported this in 17. We support it now. And I have filed my form online. So thank you.
Thank you, Mr. Jones. Any questions for Mr. Jones? Seeing none, next witness in support, Mr. Reiner.
Chairman, members of the committee, Tony Reinhardt, Ford Motor Company, here in support.
Thank you. Any questions for this witness? Seeing none, next witness in support, please step forward. Mr. Henderson.
Mr. Chair, members of the committee, Michael Henderson for the Missouri Insurance Coalition, going on record in support of the bill. Thanks.
Any questions for this witness? Seeing none, next witness in support, please step forward. Seeing none, any further witnesses in opposition, please step forward. Seeing none, any witnesses for informational purposes only? Seeing none, that concludes hearing of House Bill 1715. We will then ask Mr. Riley to once again step to the, podium or desk and present House Bill 1716. Mr. Riley, shoot.
Thank you, Mr. Chair. I am still Alex Riley, and I still represent the 134th District. Thank you for allowing me to present House Bill 1716 to you this afternoon. House Bill 1716 is a workers' compensation bill clarifying the standards for compensable injuries. And this is the first time I've had the opportunity to present this bill to this committee, but we did pass it through the Workforce Development Committee 9-4 last year, and then it passed through Rules 8-2 as well. Specifically, what this bill does is specify that for an injury to be compensable under workers' comp, the work-related issue, like accidents, occupational disease, repetitive motion, must be the prevailing factor in causing the injury, the resulting medical condition, the disability, and the need for treatment. The bill clarifies that prevailing factor is defined as primary factor. And for those of you who have read the bill beforehand, you might have initially thought that this was already the rule in this state. And there's a strong argument that it was the legislature's intent to make this rule when the prevailing factor standard was first established back in 2005, long before any of us were here. Over time, however, the courts have interpreted this statute to not require the prevailing factor standard to apply into the determination of medical care and treatment required to be afforded for a compensable injury. The bill also has some provisions allowing for the consideration of insurance benefits in determining the compensation due and allowing employers to provide medical bill payment directly to the injured worker's medical providers. Specifically, the bill is intended to is designed to ensure that workers' compensation is only being used for its intended purpose, which is to compensate employees for their work-related injuries. It's not designed for to allow individuals to try to receive treatment for other conditions they may have that aren't related to that work-related injury. So, unlike the prior bill, I don't do any workers' comp law, so this is a little outside my area of expertise. However, I've brought a number of experts with me today that have a lot more experience and knowledge in this specific area of law. So I'm happy to answer any questions, and if I don't know the answer, I'll certainly try and find somebody who does. Thank you, sir.
Thank you, Mr. Riley. Any questions for the bill sponsor? Yes, Representative Elbrecht, proceed.
Thank you, Representative Riley. Just out of curiosity, do we know how this is going to mesh with some of the language we used on the COVID vaccine bills that say all the injuries, and this one says the prevailing cause? Is that because that one, the COVID thing has any injury that's a result of the vaccine, and this one has prevailing cause stuff in it? I mean, is there harmony there, or do we have to take a look at how these puzzle pieces are going to fit
Yeah,
together?
I think we do need to take a look. That's a good question. I haven't done that, so we'll take a look at that.
Okay, thank you. Nothing further.
Further questions for the bill sponsor? Yes, Representative Rogers, proceed.
So I actually just have a very brief question, but I'm having a hard time finding it in the language here. The part where it talks about savings of the injured worker, where is that?
That is on the last page. So go to page 9. It's in the second paragraph from the bottom. So it's numbered.
Okay,
it's
sorry,
that one that's
yeah.
numbered 287.20.
So the way I'm reading that, I mean, it looks like we just did the inverse of what we've done. Is that right? Instead of
Right.
so here, and I think I just don't understand. But I read that as, you know, if somebody gets hurt at work and they've got personal savings, that they're potentially not going to be compensated for their injury.
Yeah, so that's actually not the intent of that language. It's not intended to go allowing into, you know, this situation to go look into that individual's like personal savings accounts. It's designed more to be looking at insurance. Not unlike what we just talked about in the previous bill, actually. So that's the design there. I think probably some of the folks that will be testifying can provide some more specific examples of why we're doing that here and why that's important.
And I look forward to that because I'm thinking, you know, if you're injured at work and you have a foot amputated, just terrible accident, your foot gets amputated. Do you know what that's worth for the injured worker?
I don't, but
it's worth less than $70,000, and this person got injured badly enough at work that's their compensation, which frankly is abysmal. But if they got $70,000 in the bank, we're saying, "Hey, sorry you got hurt at work," because that's I can't imagine that's the intent of this bill, but that's certainly what I read when I read the bill. So I guess the answer is other witnesses are going to clear that up.
Yeah, I think so. And if they don't, we'll work on some clarifying language.
I appreciate that. Thank you, Mr. Chairman.
Further questions for the bill sponsor? Seeing none, thank you. Any witnesses in support? And we're going to designate you the star witness. Is that all right? All right, you have 5 minutes, sir, and I think you're also new to the committee. Welcome.
Thank you.
Mr. Murphy, you're either, there you go. Press the
Bright light now.
Perfect.
Did anybody not hear everything I said before? Okay. My name is Matt Murphy. I'm an attorney out of Columbia, Missouri. I'm a defense attorney in workers' compensation. 99% of my work is in that area, and 100% of the work in that area is representing employers and insurance carriers. I also represent public entities in defense of workers' compensation claims. Just by way of a little bit of background to understand where I'm coming from, my path to my current location is pretty crooked. I spent 10 years as a claimants attorney doing comp and med mal and everything else. I spent a brief time as general counsel for the Department of Labor. I spent a few years as an administrative law judge in workers' comp, and now here I am as a defense attorney. So I've seen just about every facet of workers' compensation for the last 25, 26 years. I'm here to support this bill, and the reason I'm here to support this bill is for many of the reasons that we've already heard today. Dare I use the word windfall? Maybe we've heard that today, but that's essentially what we're here to prevent. Workers' compensation is vastly different than PI, okay? And that's the thing that we have to truly understand. There is no discussion of future medical costs in the context of workers' compensation or judgments. If there is future medical costs, it is simply ordered that future medical costs will be borne by the employer, and that is left open. If they need a new procedure, the employer pays for it, okay? So we don't have to talk about projections. We don't have to talk about what is the best evidence for what that future cost may be. What's also important to understand is the money is paid by the employer in every situation, okay? And that's important when we look at this cost savings clause. And I'll address your concern. It's a valid concern. It's probably not the best wording that was done originally, but it is not what you fear. And I'll get to that. But in any event, keep in mind what's happening here is we have this grand bargain, right? Societal bargain. And the point of this bargain is employers are free from liability for personal injury lawsuits. In exchange, they shall provide workers' compensation coverage, and they shall provide benefits. even when it's not the employer's fault. We're not talking about a fault-based system here, okay? So we have this bargain. The bargain is the employer shall provide medical care. The employer shall provide some amount of replacement for lost wages and shall provide something for disability. There's been some quarrel about the value of a foot. It's a valid quarrel, okay? That is, you all are the body that can fix that. That's not the point of this bill. And to the extent one believes that that is a problem with the system, the solution is to not then pay more somewhere else, okay? In my opinion, the solution would be to fix that problem. And so if you think you're not getting paid enough in comp, you don't get to double dip on medical bills. And that's what this is about protecting. That's one aspect of it. That's the latter half. The former half, or the first part of the bill, is to resolve some problematic case law that has created a scenario where you might have an individual 50, 60 years old, has a terrible, terrible degenerative knee. For any doctors on the panel, I understand everybody's an attorney, but in case there's any doctors as well, grade 4 chondromalacia, bone on bone, no cartilage. That individual tweaks their knee, okay, really a minor tweak, and now all of a sudden that employer is replacing the knee. Is the need for that knee replacement the result of that tweak, or is it the result of the 30 years of degeneration that individual has suffered? And should the employer, based on our grand bargain, be responsible for that? Is this a social safety net? Because that's what that sounds like. Or is it not? With regard to the latter half, is this a lottery ticket or is it not? Okay. If an employer, currently under the current scenario, if an employer provides 100% and even self-funds the health insurance and provides all the medical care under the terms of health insurance and then makes a workers' compensation claim, that claimant is entitled to claim the entire amount of those medical bills. We don't get into these charges, what's actually paid, the actual charges, and currently an ALJ will award the amount of those bills, all right? So the claimant already got their bills paid through health insurance, and then they can go to the employer and say, hey, employer, thank you for providing that health insurance, and thank you for funding that from your own money. Now I want you to pay it again. And that's not at all what workers' compensation is for. And so that's what this bill is aimed to correct. Let me just address your question, since I assume you still have the question. So that's a fair concern about the word savings. That is not at all, neither the intent nor the practice with that bill, or with that language. What that's referring to is the discount. A bill is $100, they got it paid for $70, they saved $30. The question is does that savings? It's a reference to the write-downs, okay? So granted, probably not the best way, and I don't know when that word was injected into the law, I think eons ago. So it may have just been a term of art for the day. But for the rest of the law or the bill, this would allow the employer to get a discount if those bills had already been paid, so that the employee is not paid twice. And then the final subsection, referring to the bargaining or the payment by the employer directly to the healthcare provider. Again, this is to prevent that double dipping or that windfall scenario, because everybody here is a lawyer, it sounds like. You all know how this works in practice, right? A bill is $100. Even if the employee or the individual gets $100, the first thing that plaintiff's attorney does is calls the health insurance or the health provider. What are you really going to take on this? Because we all know they're not going to hold out for $100, and so hopefully they can get it for $70 or $60 or $50 and just increase net to their client, which is their job to do. But is it the job of the comp system to provide that avenue? And so with that, hopefully I've given you a background of why I think this bill is important. I'm happy to take any questions.
Thank you, Mr. Murphy. I do practice, used to practice work comp many, many moons ago, back when Dave Clarich was a commissioner, if you can believe that. That was a long time ago.
It was a while ago.
A long time ago. And one of the cases he probably took up was the repetitive trauma cases and the difficulty we have in assessing blame or responsibility for someone who is an iron worker, or what have you, who has worked for numerous employers over the last 20 years and now develops a severe case of carpal tunnel syndrome. How do you decide who's responsible? And Those are the cases that I'm really interested in to see how this bill would affect that. Go ahead.
Well, in my opinion, I don't think the bill would affect those at all. Okay, those are difficult cases for both parties oftentimes, and I will tell you, based on the employers that I represent, I've tried 6 carpal tunnel cases in the last 18 months, I think. So I spent a lot of time in that world, and I'll tell you, it's broken 50-50 on those. I don't think this changes that scenario. Okay, the point of this bill is, in fact, to address the Tillotson case, and the facts of that case are, it was a nurse, again, a very degenerative knee, tweaked her knee. Everybody, both doctors, agreed that, look, the only way to fix her is to just give her a knee replacement because her knee is so degenerated, pre-existing. Everybody agreed that degeneration was pre-existing. And so then the courts just said, well, prevailing factor doesn't apply to the need for treatment. It only applies to the basis of the injury. And so since we have a different test, a much lighter test for the need for treatment, they required the employer into that scenario. But with regard to the carpal tunnel, if it is proved that an individual suffered carpal tunnel as a result of this employment, then this employer is going to provide that treatment. They're going to provide the treatment for the injury that resulted from that work. If the employer didn't cause the degeneration, they shouldn't provide the treatment for the degeneration. They should provide the treatment for the tweak, which is probably ice and raise it for a little while, whereas the degeneration is something that was.
I mean, the argument could also be, I'm not familiar with the Tillotson case. I'm going to ask Representative Riley to see if he'll give me a copy of that, and maybe a copy of that case for the committee, if you would, please. I guess, and I don't know if the argument was made that maybe the degenerative condition was at least exacerbated by walking the hospital floors for the last 20 years.
It wasn't in that case. That case was all about an event. Okay, it was what we call an accident case, meaning a single traumatic event occurring at or during a specific time during a single work shift, as opposed to an occupational under 067, where we're talking about a repetitive trauma.
Torn rotator cuffs, to a lesser extent, are sometimes the cuff thins, I guess, and as you get older, and becomes more prone to a traumatic event, I'll say.
Sure.
So, all right. Any further questions for this witness? We'll start with Representative Ellerbrock this time. Please proceed.
Hi. Good afternoon. I welcome your expertise in this. It sounds like you really know what you're talking about. I don't do any work comp at all, which is because I'm on one of the selection things. I have a question, though, specifically. My colleague raised it. He didn't want to ask it, but I want to ask it because it's something that's curious to me. Like, what do we do about, like, the old concept of taking your plaintiff as you find him? This nurse case that you brought up, and she tweaked her knee on the job. Sure, the injury was just the tweak, but the tweak resulted in her having to get a knee replacement. And when I was in law school, we always talked about what they call it the eggshell skull rule, right? Like, basically the court is forced to take the plaintiff the way they're found, right? So the employer in this whole grand bargain, and I actually really, I admire the workers' compensation program. I think it's a great grand bargain, all this stuff, because I'm sure you probably remember reading in law school all these cases of people suing their employer at the grain factory because a sack fell on them or something, and they had to come up with all these concepts. So we come up with this to, like, as a kind of a safety net, more or less, to make sure that employees are well taken care of and employers don't have to incur the costs of litigation over and over and over again. So where do we fit that old doctrine of, like, the eggshell skull rule, taking one's plaintiff as one finds them, into this concept, and why should we change that policy?
So 2 points, and it's a fair question. Thank you for asking it. First of all, workers' compensation has nothing to do with days of old. Okay, this is workers' compensation is not based on case law that we brought over across the pond. Right, it is a creature entirely of statute. Missouri's workers' compensation system couldn't be any more different than Kansas's, Illinois', Arkansas's, and Iowa's. Okay, for my 25 years of practicing in Missouri, I'd be committing the malpractice the second I undertook representation in another state on comp. Okay, so really the concepts that you're talking about, they're simply not codified in our workers' compensation system. Okay, and that was the decision that was made at the time that the system was created. Particularly in 2005, and one can look at what did this body decide in 2005. The standard was actually lighter. It was a test of whether it was a substantial factor, and then we tightened it up in 2005 to prevailing factor. And prevailing factor, as the sponsor and representative identified, is the primary factor in relation to all other factors. Okay, And the intent of that was to, let's clamp this down a little bit, all right? And that was the decision that the legislative body decided, and our General Assembly decided in that time. With regard to, and you used the word safety net, and that's really what we have to ask ourselves, what is the purpose of workers' compensation? If it's a social safety net, well, then it's not anymore the grand bargain that we had before. Now it's a social program of sorts, and it's a safety net like Social Security or some other safety net program that we have. And if that's the goal of workers' compensation, well, then we have that discussion. But that has not historically been the goal of workers' compensation. I don't think it is today. And when in 2005, when we made these changes that the Tillotson court was interpreting to come to their conclusion, they were interpreting language that was not, in my opinion, meant to expand or broaden compensation in the note, under this notion of a social safety net.
Okay, so I think maybe when I used that phrase, safety net, you had used it before, we might be sort of talking across our own purposes, because I don't view it as a safety net exclusively for the employee. It's a safety net for employers as well to prevent from getting sued, because with the right lawyer and the right jury, one guy can go in there and like put out your lights with a great big lawsuit, right? So the employers are protected as well. It's a safety net for employers as well, and that's part of the grand bargain. And essentially what I'm saying is, I guess what I'm getting to is, why should we change the public policy right now that creates a situation where employees might be overcompensated in some situations, but we have happy employees that are covered, that their injuries are taken care of, and they know that in exchange for that, they don't get to sue their employer, but the employer also knows they don't get or have to bear the burden of this litigation, but in some cases they will have to pay for additional medical care. And I understand that in some cases, I have a very large employer in my district. There's like 8,000 people that work at where we build the trucks that build America in my district, right? And I know that they have a really big workers' compensation bill. I know people get hurt in there all the time. But no, that's not true. They don't get hurt all the time. I take that back.
Did I hear Tony behind
people
me?
claim, yes, that's Tony. People claim that they get hurt in there all the time, and sometimes they have valid claims, sometimes they don't. But when they make those claims, Ford Motor Company knows that they also don't have to go out and defend against, like your big heavy hitter trial lawyers that are going to try to sue them for millions and millions of dollars. So essentially, this is a safety net for both sides, and why should we change this presumption that sometimes employers do kind of have to overpay a little bit, and it kind of stinks, but overpaying a little bit is way better than ending up with people that are uncared for, uncovered, unhappy workers who don't want to work in Missouri, and the employer gets the benefit of not having to actually engage in that part of the trade-off that we made, the grand bargain, so to speak, that we made here. Why should we change that public policy?
I don't believe we are changing the public policy. What we're doing is we're maintaining the public policy that was defined in 2005 by the legislative changes. What we're doing is we're changing the, not public policy, but the court policy as issued by the Tillotson case. Okay?
Well, that is public policy. That's what we do here. That's what making laws is setting public policy.
Right, but the public policy, I think the desire of this, of the General Assembly was to not pay for these, and now a court has told employers they will pay for these things, and so I think the purpose of this bill is to go back to what, in fact, was the purpose of the 2005 amendments. And keep in mind, we're only talking about that medical care that is required to cure and relieve that which previously existed, okay? If that individual suffers an injury, they're going to be compensated for that injury. They're going to be provided medical care for that, to treat that injury. What this bill is trying to do is make sure that we're not, as a result of that, picking up the tab for something that already existed. The nurse Tillotson, the moment before she took that step, when she tweaked her knee or fell and tweaked her knee, that degeneration was there, and it was not the fault of the employer. Nobody in that case, you'll have an opportunity to read it, sounds like, you'll find that there is no evidence suggesting that degeneration was the result of that employment. It was the result of her body habitus, her age, and just her genes, I suppose. Okay. Sure.
Thank you.
Move along if that's okay. Any further questions for this witness? He's saying really small. Okay, really small. Representative, go ahead.
So, and he covered most of what I was going to ask, but really just very briefly. And I've started doing a little bit of work comp the last couple of years, but I'm I'm not an expert like you are, and I won't pretend to be. But every time I've gotten involved in one of these cases, almost to a case, the employer, the insurer says, yeah, this was a degenerative condition. That's why it's a lot worse than it seems like it should be. So and you talked about the grand bargain and how it protects employers and employees, and he hit on that as well. But I just have one question, and that's that, if we push this further along to the point where somebody with degenerative health issues may not be protected if they do get hurt at work, at what point does the incentive to work go down? Because, I've got bad knees, and if I go to work and I hurt my knee, I don't have any protections. So I'm just talking very broadly, philosophically. I've got some concerns that this would discourage work.
Well, I don't profess to be one who's a social scientist or can comment on such policy issues. But just speaking as an individual, I find it difficult to swallow that an individual who has bad knees would not go to work because they're afraid they won't get comp benefits for their knees that are currently hurting them sitting at home, not working. And so, if anything, I think it'd be the reverse. Maybe they go to work hoping that they do get them taken care of, and that's the ill that we're trying to resolve. Is this? Hey, I've already got some bad knees. Maybe if I can say I tweaked my knee and I don't, or did in fact tweak the knee, and since I tweaked the knee, let's go ahead and get this other stuff taken care of that's been bothering me for years. That's the problem, and that's what makes it a kind of a hostile environment for employers, I would say.
All right, thank you. Any further questions for Mr. Murphy? Seeing none, thank you, sir.
Thank you for your time.
Welcome anytime. Make sure and fill out a witness form, please. Thank you. All right, witnesses in opposition, please step forward. I think you're new to the committee as well.
Yes, I am.
Glad you're here.
Well, thank you for having me. My name is Jason Yetzi. I work for Boyd, Kenner, Thomas & Parrish. Now I'm here on behalf of MATA and the Kansas City AFL-CIO. I'd ask you to vote against this bill, and for a few reasons, but my main concern is applying the prevailing factor standard to what is considered compensable medical care and workers' compensation. Right now, the standard is that for medical treatment to be covered under work comp, it has to flow as a natural consequence from the work-related injury. If we increase this to the prevailing factor standard, what that will do is increase the burden of proof for employees to get treated through workers' compensation. And the biggest effect that'll have is to increase litigation. Because I can tell you as a practicing work comp attorney, most of my clients come to see me because they've been denied treatment through work comp, and they've got an injury, and they're just looking to get medical care. And I think that defeats the whole purpose of workers' compensation, which is to avoid costly litigation and have a little more control over the system. So right now, I have a client who's a firefighter. He's had multiple prior knee injuries. He's torn his meniscus twice before. Had surgeries to repair those tears both times, returned to work, and he was fine. I represent him on a third meniscal tear. And so right now, he's recuperating, but it looks like he will eventually need a knee replacement. Now, under the current law, I think it's pretty clear that a knee replacement flows as a natural result from having a meniscal tear at work. If we inject the prevailing factor standard into this process, the treating physician is going to have to look at both of those prior knee surgeries and determine which of the three surgeries was the most likely cause of his need for a knee replacement. And I don't think it's really possible for a treating physician to look at all these prior surgeries and say one is the most significant factor over all of the others. It's a difficult position to put a treating physician in, and it's a difficult position to put an employee who's just looking to get treatment in. And so what would happen is it's going to lead to more denials of care for injuries that are already accepted as compensable. And an employee who would ordinarily just go through the treatment process, settle out of court with the insurance company on his own, is going to go looking for an attorney, and instead of getting that treatment quickly, getting his wage replacement quickly, we're going to have people off work waiting for months and months and months to get their treatment while the whole litigation process plays out. And that's not the purpose of workers' compensation. We need quick wage replacement, we need quick treatment, and if you inject the prevailing factor standard into the burden of proof for treatment, it will lead to increased litigation. The other subsection I'd like to point out is the amendment to 287270. And really what this does is takes away the incentive for employers to accept a claim as compensable at the beginning of a workers' compensation accident. So right now, when an employee claims he's been hurt at work, part of the incentive for an employer to accept the claim as compensable is, number one, they get to control the treatment. They choose the physicians that the employee sees, and so they've got a hand in the whole process. Number two is they get to somewhat control the costs because they choose which providers are giving this employee the treatment, and they can thus control the cost that way. Now, if you take away the right for an employee to seek the amount billed as opposed to the amount paid at the end, that takes away the incentive for the employer to treat an injury as compensable right from the beginning. Because then you're giving them the benefit of that controlled cost without actually accepting a claim as compensable. So I think if you take this away, then that's going to increase litigation just because there will be more denied claims. And more denied claims means more litigation. And so I think you really need to put a lot of thought into whether or not you want to overburden an already full workers' compensation docket for courts across the state. And the other portion of 270 I'd like to point out is that the medical bills would be paid directly by the employer as opposed to awarded to the employees. So I think that also increases litigation because when you have a denied claim and it looks like it might go to trial, having those medical bills paid by the employee's attorney as opposed to directly by the employer, that's an incentive to settle. That's leverage for me and my clients to be able to show the employers, hey, let's get this done out of court. You can take care of the bills that way, and let's get this settled. Because if we go to trial, that's leverage we have to show, look, it's going to be more expensive to try this case than it will be to settle out of court, so let's get this done. Without that, there's far less incentive for employers to settle cases out of court. And that's why I would ask you to vote no on this bill.
Thank you for being here, Mr. Yetzi. We appreciate it. I'm not sure that I buy that. What would happen if I injured my knee outside of the? Assume that I'm your potential future client. I injured my knee outside the Capitol, not work related. And I came to you and said, hey, I want to make this compensable. You'd say, well, what happened, right? And I said, well, I slipped on the snow in front of my apartment. And you said, well, that's not a work injury, correct?
Right.
Yeah. Well, how do I get my medical bills paid? Well, you'd say, go maybe run it through your own insurance company.
Correct.
So you have a lot of people coming to you say they're just looking to get their bills paid?
It's not people who don't have work injuries that are trying to get their bills paid through work comp. It's people that just want to get the treatment. That's their main concern.
But don't they already have a means to do that?
Not necessarily. People who are uninsured have no means to do that. And
I understand there are exceptions, but by and large, if they're employed, they typically have a health insurance plan through work.
If they're employed and they have a health insurance plan, they do typically have it covered.
I understand. Let them eat cake kind of situation here, but isn't it true that most people have health insurance if they're employed?
That's true, but the problem is that once you go seek treatment and you fill out that intake form at the hospital and you check, yes, this is work related, your private health insurance is going to deny the claim.
I've never seen that, and I used to represent a fair amount of people too. Does that happen a lot to you?
It does.
Okay. Well, things might have changed.
Right. So anytime someone checks that box that says it's a work-related claim, typically the insurance company is going to say, well, this isn't on us, go through work comp. And that's what happens. So when you have both the work comp insurer denying the claim and the private insurer denying the claim, that's when you get stuck with an employee who's out of work because they're physically injured, not getting treatment, and then they're just sitting at home for months on end.
Well, and I understand there are other benefits. You get 2/3 your average weekly wage. Also, you get PPD, your settlement, right?
Sure.
Permanent partial disability.
Yes.
All right. Any further questions for Mr. Yatsi? Yatsi. Sorry.
Okay.
You've been called that before, haven't you?
Yes.
Oh, Yahtzee, congratulations. All right, thank you, sir. Please make sure and fill out a witness form.
Thank you.
Appreciate your time. All right, any further witnesses in support, please step forward. We're going to go to the abbreviated testimony stage. Thank you, Mr. McCarty.
Off the rapid portion, Mr. Chairman, members of the committee, Ray McCarty, President of Associated Industries of Missouri, and also want to go on record in support of this bill. We were formed actually to write the first workers' comp law in 1919, and actually took us several years to do that. We finally got it done, and it is a grand bargain. It is, to make sure that these things are taken care of. But what we're doing here is just adding a few words that are important words, but we're adding a few words into what is already required to be for work to be the prevailing factor. And that is, rather than just being the prevailing factor in the medical condition and the disability, we're saying that it also has to be the prevailing factor for the injury and the need for treatment. And we think that's important to clarify for the courts, and happy to answer any questions.
Well, these jokes just write themselves. Thank you so much for your hard work, Mr. McCarty, back in 1919.
Thank you. I don't look that old, but I'm getting there.
Any further questions for this witness? Saying none, thank you. May leave a witness card. Any further witnesses in support, please step forward.
Committee, Tony Reinhardt, Ford Motor Company. And yes, we do occasionally have an accident, but we have a very strong workers' comp program, and believe very much in our program. Look, this has been a conversation for some time, and we're not here to try to change the law. We're saying this is a conversation that took place actually before 2005. It took place for about 10 or 12 years, and the legislature took it very seriously, and they changed the law in 2005 to make prevailing factor the standard. But through other court cases, as you heard, the prevailing factor has not been the case for the medical, and so we believe this should be consistent across the system. That's why we're in support.
Thank you, Mr. Reinhardt. Any further questions? Yes. Vice Chair Black, thank you.
Thank you, Mr. Chair. To inquire.
Proceed.
Hello, gentlemen.
How are you, sir?
I'm well. Hope you're well. We've heard that the testimony, or that this bill could increase litigation because claims that might be covered now will now be denied. We've heard that testimony. So Ford Motor Company is a premier employer. There's no doubt about it. And if this bill would result in increased litigation as a result of denied claims, where employees wouldn't be barred by comp and they could sue Ford Motor Company through someone like Ms. Dickerson, who testified previously, you are in support of this bill?
I'm in support of the workers' comp system, and we're in support of a consistent standard throughout the system, which is what the legislature decided in 2005, making prevailing factor the standard for the claims, for the injuries. And we're suggesting that because of case law, so to speak, or an individual case, that's not been the case on the medical, but all the other claims. And we're just suggesting that this should be consistent across all the claims.
Thanks, sir.
Any further questions for Mr. Reinhardt? Seeing none, thank you, sir. Make sure and fill out a witness card. Next witness in support, please step forward. Welcome again.
Hello again, Carol Mitchell on behalf of the Missouri Chamber of Commerce and Industry. The Chamber supports this bill because it clarifies the definition of prevailing factor to be the primary factor of the injury. This would prevent employers from being held responsible for more medical treatment than is necessary to correct the workplace injury. It also allows for more fair compensation by considering any savings or insurance by the injured employee or employer.
Now, do you really think that's true pursuant to Section 287.172?
You're going to have to brief me on that.
Okay. Any questions for this witness? Seeing none, thank you. Make sure to fill out a card.
Thank you.
Mr. Jones.
Mr. Chairman, Brad Jones with the NFIB in support of this bill, and I have filed my thing. And by the way, Reinhardt and I were here in '93 when they did the rewrite of the, I like to mention that to Tony.
Thank you. Any questions for this witness? Seeing none. Next witness in support, please step forward.
Mr. Chair, members of the committee, Michael Henderson for the Missouri Insurance Coalition in support of this bill. Thank you.
Thank you, Mr. Henderson. Any questions? Say yes, Representative Rogers.
Assuming this bill becomes law, can we expect some insurance breaks at our small businesses?
I'm not sure what you're referring
Well,
to there.
so, I mean, I assume we're asking for this bill to become law to, because it's good for business. We're hearing it's good for business. We're hearing it's good for insurance. So I would assume that people paying insurance would get a discount in their insurance if we're making laws that are better protecting.
I think that clarification of the law, of the laws in this state is good for business, it's good for insurance, and I think when there's confusion that results in increased litigation, I would argue, contrary to what the witness in opposition to this bill stated earlier, when you have a law that's being interpreted by some courts to say, on the defense side, hey, we just have to treat a tweaked knee, but it's allowing the claims attorneys to get up and say, no, you have to replace the whole knee, that actually increases arguments over what is compensable under the law, increases cost of litigation, which ultimately, logically, we would argue, does drive up the cost of insurance premiums. So I think when you provide clarity under the law, that's good for everybody in the system.
And that's my point. That's where, and I truly see where you guys are coming from on a lot of this stuff. But we've been doing this. I've been on this committee for 2 years. We've heard all kinds of bills that just tighten things up and make things apparently more efficient. But I've yet to get a break on any kind of insurance, and I'm just hoping at some point that happens if we continue to pass tort reform. Thank you.
Understood, Representative. Thank you.
Any further questions? Seeing none, thank you, Mr. Henderson.
Thank
Make
you.
sure and fill out a card. Next witness in support, please step forward. Seeing none, any further witnesses in opposition? Seeing none, any witness for informational purposes only? Seeing none, that concludes our hearing on House Bill 1716. Thank you. We will be meeting next Tuesday at approximately noon. We'll exec on the two bills we heard today, as well as maybe hearing a couple new ones. Thank you. Have a great day.